Awesome, guys. Well, I think we'll probably kick off on getting started. I guess a quick reminder, we're going to be talking about running your business through a trust and the different ways that that can be structured. There are quite a few options, and trusts can be a complicated area of both law and accounting. So would always recommend getting the relevant support from the Lawpath team. Some things that we can assist you with are ongoing legal advice, accounting support. But I guess just to cover what we're going to touch on today, we're going to, obviously touch on what Lawpath does, who myself and Damin are. We're going to talk about the different types of trusts, the advantages and disadvantages of running your business through a trust, and then some legal and tax considerations. We'll have a little Q&A at the end, have a question and answer time, as well as go over how Lawpath services can assist you. But yeah, we'll be taking some questions throughout the call. So just, pop your questions into the Q&A. You fill in that poll. It's really useful for us. And yeah, we'll get started. So who am I? Some of you may have interacted with me if you've used our services previously. I've worked in quite a few of the different teams at Lawpath, but I'm now the legal services team leader. So what does that mean? It means I work kind of between yourselves and the lawyers here at Lawpath. We've grown the team quite significantly over the past 12 months. So you see a lot of new lawyers doing our quoted pieces of work and legal advice calls. I also lead the assisted trust package. So this is a new offering we've kind of rolled out in the last 6 months and just really streamlines our trust registration process. I'm also the primary account manager for all of our incubator, accelerator partners, university clients, as well as retainer clients. So quite familiar with working with startups and new businesses. And my personal history, I used to be a licensee in a large hotel, so used to large scale hospitality. But I think the key part of that is I understand, I guess, the operational side of running a business and what it can be like on the front lines. Cool. So how Lawpath can help. So there's quite a few different areas that we help, and we aim to be a one-stop shop for business requirements. We can assist you with your contract management needs with our contract template library. Our e-sign collaboration and AI tech that we've built into the platform are all designed to make your contract management requirements as easy as possible. We've also built specific workflows, including a trust establishment workflow that you can utilize in your business to help guide you through specific legal tasks. And you can also book in legal consultations through our legal advice plan to understand and guide you through your business legal requirements. Awesome. Go to the next slide, Damin. Too easy. Damin, would you like to introduce yourself?
Sure. I was just fixing my audio. Is that any better? Let me know. Before I was too soft. So if someone can let me know whether you can hear me okay, that'd be great.
Yeah, put some.
Just the same as before. How about you, Glen? Can you hear me?
I can hear you okay. I'm using my headset though.
I will crank it to the top. How about now? Any better?
Yeah.
Okay, great. All right. So about myself, I've been around as a lawyer for over 15 years. I've run my own law firm since 2012. So there's been about over a decade of being the legal practice director. I primarily specialize in the area of commercial law. So over the years, I've worked with probably around 2,000 startups. I do a lot of capital raising, corporate structuring, including the establishment of trusts. I've done a lot of litigation as well, and I've practiced in Brisbane, Melbourne, Sydney, and I have a master's degree from Europe in international trade law, and my law degree also had a specialization in international trade law. So we do a lot of international transactions. And today, if you have any questions about this presentation, feel free to ask them. But if you have any other questions, I'm happy to answer anything. So we'll get straight into it. So the first thing, we're talking about trusts and what are they? And so the first thing we normally talk about is who are the parties. So a trust, you can think of it as almost a contract. It's a trust deed, which is a document that basically lays out the rights, obligations, and powers of the different parties that are involved. And so as a starting point, there's someone called the settlor. The settlor is normally the accountant or the lawyer that establishes the trust for you. They aren't allowed to have any interest in the trust, either at the time of creating the trust or ever in the future. And so they're totally independent, and they're there to bring the trust into existence. And what happens is the settlor normally puts $10 or gifts $10 to the trust for the establishment of it. We then have the trustee, and the trustee is essentially, you can kind of think of that person like the CEO. What they do is they're responsible for making all the decisions of the trust. So if they ever need to sign a contract on behalf of the trust, it's their signature. They are the ones that make the decision on who's going to get what contracts to enter into, where to invest their money, and so on. But then there's the appointer, and the appointer is more powerful than the trustee. The appointer is someone that actually appoints the trustee and can remove that trustee. So at the end of the day, the appointer has the ultimate control, so that if the trustee goes rogue, they can terminate that trustee, and then they come in and appoint a new one, maybe theirself. And then finally, you have the beneficiaries. And the beneficiaries are those who may have an interest in the assets of the trust, but only when the trustee declares they have an interest. So in essence, the trustee's job is to deal with the assets by entering into transactions, signing contracts, distributing it, investing it, buying assets, things like that. But at the end of every year, generally, they then get to decide, well, which beneficiary, if any, gets a distribution from the assets. And it's not until that actual distribution is declared by a trustee that entitles the beneficiary to anything. So in essence, the beneficiaries aren't entitled to anything until the trustee declares it. Now, there is various different stories about how trusts came to be. This one, I like it because it makes it sound kind of fun and interesting. And essentially, the story that I was told when I was studying law and in my junior years of a lawyer was when a knight used to go off to war, they would leave all their assets behind to their brother or their relative to look after the home, look after the family. And then they would go off to war, and the brother would say, oh, well, he's not coming back, so I'll move into the house and I'll take all his assets. And then when the knight did come back, the brother had everything and the knight lost everything, all his life savings, because the brother had taken it. So the king then established trust, which was essentially where the settlor was the king. The king would create a trust, and the knight would then have a trust, and they would appoint their brother to be the trustee, to look after the assets, but the knight would be the appointer, which would mean that when they went off to war, when they came back, if their brother had gone rogue and wouldn't give their assets back, then the knight would be, as the appointer, would be able to remove the brother and come back and take over all the assets. So that's kind of how old trust law is. And there's many, many cases that go back hundreds of years when we look at trust law. So as I mentioned before, generally speaking, a trust is created by a trust deed. And again, it's just a contract, if you were to look at it from a layman's terms, that looks like it says you're going to appoint this person has these powers, this person can amend it, these persons can do declarations of declaring who gets the assets, things like that. But when we look at the trustee can be an individual or it can be a company. And it doesn't necessarily need to be you. So you might create a trust as you, the appointer, but you could then create a company, which is the trustee, where you're the director, shareholder, and secretary of that company. The general reason why people like to do a corporate trustee is because it helps with succession planning. So for instance, if you were the appointer and you were the trustee and you were the beneficiary and your children were the beneficiaries and your spouse was the beneficiary and you were to die, no one can really do anything with that trust because you're the appointer and you're the trustee. And then you have to go into the trust deed, and you probably have to go and do probate under your will to make sure that the next person coming in as the appointer and trustee has the powers granted by the court to come in. Whereas if the corporate trustee, if it was a company, and let's say you and your spouse were the shareholders, but just you were the director, if you were to die, then your spouse could come in and appoint itself as him or herself as the director and continue on with the trust assets without having to go get probate, because you use the corporation's law to fill in that directorship that's been lost. So it does help a little bit in terms of succession planning to have a corporate trustee. Now, as a trustee, the person that's in charge of the assets, they have an obligation to do their best interests for the beneficiaries and for those assets. So they have to act in the best interests of the trust. So they can't go and give themselves money as trustee. However, the trustee can also be a beneficiary. And if the trustee declares themselves as being the beneficiary that's entitled to the benefit of the assets, then that's okay. Even though they're potentially, if you look at it in one way, are acting in conflict, as the beneficiary and as the trustee, they can make that decision because the trustee can declare what beneficiary gets what assets every year at its absolute discretion. And you might have seen some of the Gina Reinhardt cases in the news in the past, where Gina Reinhardt was running a trust, and the trust was about to come to an end. And within that trust, her children were also beneficiaries of the trust. And rather than distributing the assets of that trust to the beneficiaries at the end of life, Gina decided to extend the life of the trust so that she didn't have to distribute the assets to the beneficiaries at the end of the life. And that ended up looking into the fiduciary relationship of her as the trustee and whether she acted in the best interest of the trust assets or whether she acted in the best interest of herself. But in essence, you got to act in good faith, not in conflict, not to profit yourself. And if you were to steal trust assets, for instance, then there's various different remedies that can be taken, such as what's called an account for profit. So if you paid yourself money as a trustee that wasn't allowed under the trust deed, then any money that you earned from that distribution or from that remuneration that you received, the trust could potentially come and sue you for the profits that you derived from that. And also, if you were to take remuneration from the trust without complying with the trust deed terms, then there could be orders that the money that you've received are held on constructive trust for the benefit of the trust. Now, one of the things about a trustee or a trust is also it gives you, one, asset protection, and two, it gives you tax benefits. When we look at the asset protection side of things, it does depend on how you actually create your corporate structure. So this is a fairly standard corporate structure that a lot of people will use in creating their company. And I'll just explain this briefly so you get an idea of how it can benefit you from an asset protection side of things. So if you had a trading company, let's say Jim's Landscaping franchise, for instance, Jim's Mowing, and it was a trading company, but let's say, for instance, you were buying a lot of machinery, a lot of equipment. Well, if you bought that equipment in the trading names company and you were then sued, for instance, or the franchisor terminates its franchise agreement on you and you are sued for breach of your restraint of trade and starting a competitive business or something like that, then you would be able to possibly lose all the machinery that you lost because the machinery is owned in the trading name or in the trading company. But if you bought all your machinery in the holding company that 100% owns the trading company, then if someone sued the trading company, they wouldn't be able to get access to your equipment because the equipment's not owned by the trading company, and instead it's owned by the holding company. And if the holding company is then 100% owned by your family trust, and you are, let's say you were personally sued for insolvent trading or the trading company going under, and you personally were sued by the franchisor because you breach your restraint of trade, they could sue you for loss and damage and possibly bankrupt you. Now, if you personally owned all the shares in that trading company, or if you personally owned all the shares in the holding company, then the trustee in bankruptcy would take your shares. However, if you hold the shares in a family trust is a separate legal entity. So even though you personally could potentially go bankrupt, the trustee in bankruptcy cannot go after the assets of the trust because the assets of the trust aren't owned by the trustee. The assets of the trust are held on trust for the beneficiaries, and therefore it's not your personal asset. And for that reason, it protects your shares in your business from someone being able to come after those shares. Another example is if you have a software company, standard process is you create a holding company, your family trust owns all the shares. So the trustee owns the shares for the benefit of your trust. You develop all the software in the holding company, and then that holding company then licenses the software down to a trading company that operates. The operating company or the trading company is then sued. Well, the holding company claws back all the intellectual property under its license agreement, and then the trading company is left with possibly no intellectual property because it's all actually owned by the holding company. So these are just kind of structures that a lot of people use to protect their assets as they build it. Now, there's benefits and there's also disadvantages to trust, which I'll talk about in a moment. But another thing, just while we have this diagram here as an example, is that if your trading company, let's say, made $100,000 worth of profit, the trading company then pays 25% tax on that profit. Now, because the company's already paid 25% tax, it then issues a dividend up to the holding company. Because that holding company is at the same or similar tax bracket, all the tax has already been paid on it. So the holding company normally doesn't have to pay any tax at all when it receives $75,000 because the trading company has already paid tax on it. So then the holding company will then distribute dividends to the family trust. And then once the family trust gets that money, which is the $75,000, the trustee then decides which beneficiary is going to get the $75,000. Now, if you were the only beneficiary, you would then pay yourself the $75,000. And this is what we call a franked dividend. Because the company's already paid 25% tax on it, when you receive the $75,000, you only have to pay the tax that's difference between your normal income tax bracket and the company's income tax bracket. So just using equal numbers, if you were in the 40% tax bracket, then you would only have to pay 15% tax on the $75,000 that you received because the company's already paid 25% tax. But then let's say, for instance, you have, as a beneficiary in your family trust, you, your spouse, and your children, you might be able to do what's called income distribution, where you take the $75,000 and you give yourself maybe $20,000 and you pay 15% tax on it. You might give your spouse $30,000, and if he or she's not working, then she'll be in the lowest income tax bracket and might not have to pay any additional tax on that amount. And then you might distribute $10,000 to each of your children's education funds, for instance, which again is in the low income tax bracket, which means that instead of paying the extra 15% tax that you would have paid on the entire 75%, you would only have to pay potentially 15% tax on the 20,000 you received and nothing on the other side. So that's what we call income distribution, and that's where accountants come in to help you. It's definitely not tax evasion, and we're not promoting tax evasion. It has nothing to do with tax evasion at all. It's what's called income distribution, and it's for one, asset protection, two, income distribution to help you in basically figuring out how to structure your business in the most efficient way. Now, there's different types of trusts. So we have what's called a discretionary trust, which is also known as the family trust, which most people create. And we have a unit trust. A discretionary trust is, as I mentioned, the trustee gets to decide what beneficiary receives the distribution each year. Now, the trust has to distribute that money every year. So when you get that 75,000, the trust shouldn't be just sitting on that money and keeping it. That trust has to distribute it to the beneficiaries. And if it doesn't, it will then have to pay tax, I think, of about 15% on the money that it doesn't distribute. So you get pinged for not distributing the money to the beneficiaries. Again, you'd have to talk to your accountant about whether you distribute it, whether you hold it, where to put the funds, things like that. Possibly whether the actual trust company actually ever, or the trustee, or sorry, the trading company actually ever distributes dividends, and the holding company actually issues dividends. And that's kind of the benefit of the dual trust structure or company structure, is that trading company can issue its dividends to the holding company, but the holding company can just hold the money. It doesn't actually have to send it off to your trust, but the money in the holding company is protected because it's one step removed from all your customers. So your holding company can actually be a bank and just hold that money there and then reinvest the money back down into the trading company as a loan, which is secured. So it protects the money and allows you to reinvest your money back into your trading company. Or the holding company can then put it into your trust if you want to then distribute the money to the beneficiaries. But at the end of the day, the trustee has the sole discretion on which beneficiary gets the distribution. There's no limits on the discretion. It's absolute. And they have absolute control unless the appointer comes in and removes them and appoints someone else. And this is a common structure that's used for small business. The other side is a unit trust. A unit trust is fairly often used in property transactions because, generally speaking, capital gains tax can be distributed along with the income to the unit holders. So whereas a trustee has the discretion on what beneficiary gets what distribution, with a unit trust, when the trustee declares a distribution, it then goes to each unit, and it depends on how many units you hold to depend on what the size of the distribution. You could kind of think of it as shares. So let's say, for instance, you distribute, or the unit trust receives $100,000, and there's 50-50 quote unquote shareholders, but they're actually unit holders. Then 50,000 would go to one unit holder and 50,000 would go to the other unit holder. There's no actual discretion on the trustee at all to say, well, we'll only pay this one unit holder some distribution and not the other. So it's a fixed trust. And with a fixed trust comes different tax advantages, but it also comes with less flexibility as well. Now, when we look at the advantages of the trust, as mentioned, you got the asset protection, you have not necessarily tax minimization, but it allows for tax distribution to potentially distribute to people who are in lower tax brackets. And it gives you the it gives you the flexibility to decide which person actually receives it, and it can help with succession planning. The disadvantage, however, is that it is fairly complex in terms of the structure, in terms of how you manage it. From a tax perspective, you need to understand how to deal with the funds, how to distribute the funds, whether to distribute the funds, whether to actually pay out dividends to your trust, because it might be that you're already in the highest tax bracket and you might not want to receive an income that year. So you might just retain that money in your company rather than distributing out to you and then you getting hit with personal income tax. There's cost for establishing it. So when you look at creating the trust, you also have to do a tax return every year, and you also have to pay stamp duty in the creation of it. With the tax returns, you got to do the ongoing maintenance. So it's like a separate entity. So it's not just your normal company where you do your tax returns for that, and then you pay yourself your dividends, and then you pay, and then you do your normal tax. This trust structure is a separate entire entity that also requires another round of accounting done every year as well. And so when we look at some of the tax considerations and the ongoing costs, the benefit of the trust, well, the disadvantage is that you got the administrative costs. You've also got the legal and tax costs to create it. You have to make sure that the trustee that you appoint is someone that you trust or yourself. And if it's a company and you have more than one shareholder, you probably need to get a shareholders agreement to deal with the management of that trust, the trustee company as well. You want to look at the trust terms of who you can distribute to and who's not allowed to get distribution. So in most states, a couple of years ago, they passed new state law talking about foreign persons. And so if you were to ever buy property with your family trust and you do not exclude foreign persons from your trust being beneficiaries now or ever being allowed to be a beneficiary of your trust in the future, then you could get pinged with extra tax because you have the ability of foreign persons becoming a beneficiary of your trust, which would then create your trust as a foreign person trust. So you need to make sure that foreign persons are excluded completely from ever being part of that trust for you to buy property in it to give you that benefit. And then you want to look at whether you're going to put any charities into that trust as well. There's things called bucket companies, which some people have, which I won't get into, but you can talk to your accountant about that. It's just creating basically another company to be a beneficiary of your trust. You want to look at your tax returns, as I mentioned, and your tax reporting, and how each person that's going to receive the distribution will be taxed as well. So there are some, it's mostly an accounting and tax side of things once it's actually being established. Now, the process to create a trust, you select the trustee, you select your beneficiaries, you select who's going to be the appointer, you select who's going to be the settler, you have the trust deed created and drafted up by normally a lawyer. You then pay stamp duty on it. You then possibly apply for an ABN and TFN, but a trust itself normally doesn't have an ABN because it does not trade. It's the trustee company doesn't have an ABN because it doesn't trade in its own capacity. It's the trust that's doing the dealing. So the trustee company or the trust gets the ABN, not the trustee. And then you have to get a tax file number as well. And then you normally need to open up a bank account. So I'll leave that for now. We'll get into some of your questions and I'll pass it over to Glen and he can get into some information about Lawpath and then we'll come back to the Q&A.
Yeah, awesome. Thanks, Damin. I guess you can all appreciate it's a pretty complex area of law. So getting the right legal support is really key to assist you. And, Lawpath is a great place to come to because we can assist with both your accounting and legal side of this, as well as other business requirements. I guess traditionally, law firms, it's hard to access for a traditional structure. The power dynamic heavily favors the lawyer. Lawpath aims to make the law easy to access, provide price transparency, and simplify your legal matters. And we have a few options that we can present to you for helping you get your trust set up through us. So the first one is we do have templates in our legal contract library. I would recommend steering clear of this unless you're very confident or have some legal support or experience. It can be quite complex and there are a lot of wrong turns that you can take. So I would recommend at least getting some advice from a lawyer before setting up a trust. So yeah, we've got both unit trust deeds, fixed trust deeds, variations of trust in our library, discretionary trusts, bare trusts. It's all about using the right documents though, so getting some legal advice is really key for reducing errors. What I would recommend is utilizing our legal advice plan. This gives you unlimited access to our lawyers for 30-minute calls. You can discuss your business structure, trusts, anything commercial in nature, really, including IP, trademarking, employment law. So it really is a single solution for a business that will give you, the answers you require. Especially running a trust through a business can be a little bit more complex than just running a standard company structure. So having unlimited legal advice is a great asset. We also have accounting advice in the same structure. So when you're utilizing a trust, as Damin mentioned, you will need to make distributions throughout the year. You might have questions as to GST, tax law, other things that might arise utilizing a trust. So having unlimited accounting advice as well, I would definitely recommend utilizing that if you're considering running a trust. What I work in, the Lawpath legal team, we do the assisted trust package. So if you're a member with us, we can do this for $900 as a legal fee. For a market comparison, most firms will charge around $1,500. We can act as a full service in certain states. So please do inquire with me directly so we can work out what that package would look like for you. We would need to work out which state you're in, as there is state-specific stamping fees, which vary greatly. So I'm more than happy to have a conversation with anyone interested to work out what that pricing would look like and work out a package specifically for your needs. So please do reach out. As I mentioned, we have the Essentials and Legal Advice Plan as subscriptions as well. So the Essentials plan is normally valued at $468 per year. That gives you access to the full document library. I would recommend, if you're considering a trust though, the Legal Advice Plan. This is normally valued at $179 a month for a 12-month commitment. It gives you access to unlimited 30-minute calls, as I mentioned. So getting that legal advice is really key for utilizing a trust. We do have some bundle options. So if you wanted to put together the legal advice, the accounting advice, and tax, you do get up to a 40% discount. So let me know if you're interested in a bundle option and we can work out what would be the best fit for you.